I'd like to call the GMAC meeting back to order. We have a second panel today to talk about the regulation of foreign-based CEFs. We have joining us some CFTC staff. We have Vince McGonigal, the director from the Division of Market Oversight, David Van Wagner, the chief counsel from DMO, and Reva Spear, the senior special counsel from DMO as well. So with that, Mark, do you have any comments you want to make at the beginning here before we turn it over to the panel?
Just one real quick comment. I alluded to it earlier this morning at the beginning of the meeting. We have in place an interim solution for these trading venues overseas, in London in particular, but we've always viewed it as an interim solution. I see on the screen here there's a recitation of the statutory provision that gives us the authority to provide this status for offshore trading venues. And so it's been the plan for a number of months now that we would follow up the interim solution with a more permanent solution, if you will. Staff has been working very hard on that. We've discussed a preliminary term sheet on what this kind of regime might look like. David and Vince and Reva will get into more detail there about what the current thinking is on the part of the staff. But we're, as with the morning session, looking forward to input from this group to further clarify our thinking on how we might approach this. The other quick comment I'll make is that we have a couple of people around the table here who will have very, very unique perspectives, I think, on this. And so looking forward to hearing some comments from them. By that I mean the platform operators who've sort of wrestled with this and our rules and have tried to sort out market solutions that are legal ones in both jurisdictions where they operate. So looking forward to the session. Thanks.
And again, this afternoon, we also have June Mizuguchi and David Bailey joining us for the second panel, too. But with that, I'll turn it over to the CFTC staff to give their opening remarks.
Thanks very much. I'm David Van Wagner from the Division of Market Oversight. So shortly after the Commission adopted its swap execution facility rules, CFTC Chairman Gary Gensler and Michel Barnier—
David, move the mic up, please.
Oh, really? Okay. Is it better? Okay. Shortly after the CEF rules were adopted in May 2013, CFTC Chairman Gary Gensler and Michel Barnier from the European Commissioner for Internal Markets and Services announced a path forward statement reflecting their joint understanding of how to approach cross-border regulation of derivatives. This path forward statement provided that if the CFTC's trade execution mandate, the mandate by which swaps that are subject to our clearing mandate and have been made available for trading on a CEF or a DCM, if it became effective before March 15 of 2014, the CFTC would write no action letters to provide relief to certain European regulated multilateral trading facilities, or MTFs, and provided that those platforms were subject to a sufficient level of pre- and post-trade price transparency requirements, comparable provisions providing for non-discriminatory access by market participants, and an appropriate level of governmental oversight. The CFTC's trade execution mandate indeed became effective on February 15, 2014, with respect to certain interest rate and credit default swap contracts that were determined to be made available to trade. So in fulfillment of the Commission's path forward commitments, the Division of Market Oversight and the Division of Swap Dealer and Intermediary Oversight issued on February 12th a no-action letter offering conditional relief for qualifying MTFs from the CEF registration requirements, and also for parties that were executing swap transactions on these qualifying MTFs, they would be relieved from the trade execution mandate to the extent that they traded a trade execution mandate swap. The conditions for relief that were imposed on the MTFs generally tracked the purposes underlying the path forward statement, and so they included things such as to promote the pre-trade price transparency, the qualifying MTEF would have to use an order book or an order book plus an RFQ trading system for execution of swaps subject to the trade execution mandate. To promote post-trade price transparency, the qualifying MTEF would have to report all the swaps executed on the platform to a CFTC regulated swap data repository or a provisionally registered SDR. The MTEF would also have to provide non-discriminatory access to its platform in a manner that was comparable to the CFTC's impartial access requirements. In addition, the MTEF would have to have an appropriate level of trade practice oversight. And I should stress that each of these conditions, the substantive MTEF requirements, would have to be grounded or based upon home country regulations or requirements versus the MTEF self-imposing the requirements on themselves. On April 9th, the Division of Market Oversight and the Division of DSIO revised the MTEF relief letter to adjust certain of the requirements, but of the original February 12th letter, and they were tweaked in fairly small regard, I guess. To date, we haven't granted any relief to any MTEFs under this letter. So an important note to add, and that is that the MTEF no action letter was intended to provide transitional relief until the Commission adopted a formal CEF exemptive category for foreign-based platforms, as is anticipated in the Commodity Exchange Act. Accordingly, relief under the MTEF no action letter would expire with the adoption of the CEF exemptive category rulemaking, which Riva Adriance will discuss and pose questions around. I've spoken here only about the path forward and only about MTEFs. But in addition to that, staff has also reached out to a number of other foreign regulators who would be potentially interested in the same basic framework of the MTEF no action letter that we issued. We're still having discussions around the possibility of using that template elsewhere. So there might be more to follow. So, but that's really it on the MTEF no action letter, segueing to the exempt CEF rulemaking.
Thank you, David. I don't know if this is close enough. Try and do this without pulling it out of the plug. Okay. All right. As was mentioned, this is there is the Act provided authority for going forward with more than just a no action letter, but something more permanent. So maybe this will help. And it's on here. I'm trying to figure out how I can get this up. We do have the statutory language, if we can somehow get it up there. I don't know if anyone can read this, but the reason I wanted to actually have it posted up here is because, thank you, because the language is many times people will mention that there's this authority for the Commission to exempt CEFs, exempt swap execution facilities under certain conditions and under certain circumstances, but very often the details of that authority are not necessarily understood. And as so I want to just, this is something that was discussed this morning by Phyllis, discussed the statutory authority for exempting derivatives clearing organizations. And this, if you look at this statute, the statutory language up here, you'll see that similar to the Commission's exemptive authority discussed this morning, Section 5H paren G of the Commodity Exchange Act provides the Commission with authority to exempt, conditionally or unconditionally, a swap execution facility from registration if certain conditions are met. In order to grant an exception an exemption to a foreign-based swap execution facility, this statutory authority requires the Commission to make a finding, to find that the foreign-based swap execution facility is subject to comparable comprehensive supervision and regulation on a consolidated basis by the appropriate governmental authorities in the home country of the facility. So the Commission has a certain standard that is required of the Commission set out here. And I want to point out that this exemptive authority, as I said, closely mirrors the Commission's exemptive authority to exempt from registration under certain conditions some foreign derivatives clearing organizations, and both provisions provide that the CFTC may do so conditionally or unconditionally. In addition, both provisions contain a substantially similar requirement that in order to provide this exemption, the CFTC must make a finding. And so, therefore, it is that limits under what conditions we can provide that exemption. To repeat a point that Phyllis made this morning, the finding required of the Commission focuses on the regulator and the regulatory requirements imposed by that regulator rather than focusing on the foreign-based swap execution facility. So the basic standard goes to the regulator and the regulatory scheme. Due to the fact that this is a parallel statutory authority to that of the authority provided to the Commission in connection with clearing organizations, the exempt SEF rulemaking team, and we do have a team, and we have team from across the Commission, this team expects that the proposal it eventually provides to the Commission for consideration would, in many ways, track the any exempt DCO rulemaking that the Commission would approve for publication. So, for example, similar to an eligibility requirement mentioned by Phyllis earlier, and was also kind of mentioned by some others, the rulemaking team expects to propose an eligibility requirement that a memorandum of understanding or other similar arrangement was in effect between the Commission and the home country regulator. As was mentioned this morning, there needs to be a mechanism for good communication coordination. So in a similar way, we would expect a number of those kind of basic structural administrative kind of proposals would be very similar. However, the Commission faces an important difference in the application in the CEF context in terms of making this finding that this home country regulator has comparable comprehensive supervision and regulation. So this standard is under the draft proposal discussed this morning. When Phyllis was discussing the standard to be used in clearing organizations, she was able to turn to a standard that was that regards the regulatory framework that was consistent with the Principles for Financial Markets Infrastructure, the PFMI, which, as you all know and was mentioned, was something that were established through joint international efforts. The Commission was a key contributor to those efforts, and it currently serves as a member of the, this is less my familiarity, the CPSS IOSCO task force that monitors implementation of the PFMIs. Okay, and in terms of that, so the Commission has, since the adoption of the PFMIs, the Commission's amended its regulations to establish regulatory standards that are fully consistent with the PFMIs. And so in this way, the Commission has been treating, for my language as another division, so this isn't my familiarity, but my language is that this is being viewed as the PFMIs are comparable to the supervisory and regulatory framework established by the Act and our regulations, and therefore comprehensive, consistent with the requirements of Section 5B paren H of the Act, or similar to what we require for derivatives clearing organizations. So there was a standard that the Commission could adopt and use as a standard for making that determination as to whether the particular foreign derivative clearing organization was supervised by an appropriate regulator that met the standard required under the Act. Okay, so that's a great tool that they had. Unfortunately, the regulatory framework applicable to swap execution facilities under the Act, which was implemented by Part 37 of our regulations, has no comparable standardized international principles that have been established concerning appropriate oversight and supervision of swap trading platforms. Consequently, while we have Part 37 to use as a baseline regarding supervision regulation, we cannot turn to any joint international standards to rely on when considering whether a foreign-based swap execution facility is subject to comparable comprehensive supervision and regulation on a consolidated basis by an appropriate governmental authority in its home country, as compared to what we have. So we have Part 37, but we do not have an international standard that we can compare this to. So therefore, the exempt SEF rulemaking team is now in the process of considering what standard would meet the statutory requirement. And we're doing so without prejudgment. We're trying to understand what does this statutory standard require of the Commission. And the team, therefore, has quite a number of questions on this topic, and we would like to pose a number of the questions today to help the team formulate this regulatory standard that we have to try and draft so that we can provide a proposal to the Commission. So therefore, I'm coming today from a different position from what was earlier, where the team that had worked on that rulemaking had gone through and considered a lot of different issues and made some conclusions that they were going to provide to the Commission shortly. We are starting out at the beginning, and therefore we are guessing that you all have a lot of opinions on this, and we would like to get those opinions as we consider this.
Terrific. Before we open it up for full discussion, David, would you like to make a few comments?
Yes, thank you, Chairman. I've got a number of thoughts on this, but much of what I said this morning with respect to the need for and the process to implement an exempt DCO regime apply to the trading venue space and a potential exempt CEF regime, as David and Riva have been outlining. So I'm not going to repeat my comments from this morning, but the broad construct applies. I'd also note that this is an area of trading where we've already seen real fragmentation in the market between the US and other jurisdictions, and specifically between US person liquidity and non-US person liquidity, as we've seen reported extensively within the, for example, but not exclusively, the ISDA statistics. And I think we should just bear in mind that fragmentation has the potential to have a really negative impact on the outcomes that end users achieve in markets and on overall market resilience in times of stress. So from our perspective, having an exempt CEF regime and having something comparable in other jurisdictions, including the EU, is absolutely essential. In terms of, I'd like to highlight two issues for this discussion. Firstly, that we have precedents in terms of cross-border regimes for trading venues that I think we can usefully look to see what worked well and what hasn't. And secondly, I think it's fair to say that the pace of regulation in the trading venue space between different jurisdictions is especially stark in the case of trading venues as compared with post-trade issues. And I just want to highlight a couple of consequences of that. So on the first point, I'd just like to highlight that a good example of a cross-border regime is the way that, for example, the FCA or the FSA, as we once were, and the CFTC have collaborated with respect to derivative exchanges. From a UK perspective, we have what's known as the Recognised Overseas Investment Exchange regime, and from the CFTC's perspective, you have the Foreign Board of Trade regime. And those allow overseas exchanges to operate in our respective jurisdictions and remain supervised by the home supervisor on a day-to-day basis. We've got great collaboration with colleagues here at the CFTC in making that happen. We had a delegation across discussing the regime only last week. And their success was recognised in the path forward. And I think they are a really good example of how a cross-border regime can and should work. We've also, as David's outlined, we have got the example of the interim qualifying MTF regime, which was announced the day that this committee last met back in February. here's an example of something that hasn't worked as effectively as we had intended, but there's a number of reasons for that, and to a large extent that comes down to the fact that Europe, at the time that was put in place, was still developing its rules for trading venues for OTC derivatives. But I would like to highlight a couple of points that we have learnt from the experience of putting together the interim QMTF regime. The first is that if there's an equivalence, the first is if there are a significant number of top-up requirements or additional conditions placed on a regime, it makes it very difficult for market participants to amend the way they do business to meet those additional top-up requirements. And the second point I'd like to highlight is that the qualifying MTF regime contained a footnote, and we've long experience of making sure we always read the footnotes in CFTC releases. Had noted that in the case of significant participation from US venues, from US market participants, then the CFTC reserved the right to amend or remove the exemption. And that has caused a significant amount of comment, and I think I'd say concern amongst European participants around and European venues around how that would operate in practice. So a lesson from that is clarity on such requirements, and if possible, not having those requirements would make a regime work more effectively. So there's a couple of points there that we've learned from the qualifying MTF regime so far that I think we need to take forward. In my view, it serves as something we can work with as an interim measure, but it's not a template on which to base a long-term exempt CEF regime. My second point aligns with that, which is European trading requirements for derivatives are only just being finalised. The MiFID legislation has only been agreed back in April and is shortly to be published in the European Union's official journal. But it does mean that we now have confirmed regulations, and we'll see imminently from ESMA a consultation on the rulemakings underneath those requirements. These now give us the basis for a workable cross-border regime with respect to long-term regime with respect to OTC derivatives. And in terms of what that should look like, well, I think that can follow the same basis that I described this morning. It can follow an outcomes-based jurisdiction-level assessment of equivalence. To Riva's recent points, I think we do have a basis. We do have an international set of agreed principles on which trading venues for OTC derivatives can be based, and that is the February 2011 IOSCO report on trading of OTC derivatives, which contains a number of principles which have been enshrined in the way that Europe has developed its regime. And I think they are a starting point for the assessment of equivalence, and they were jointly developed by authorities including the UK FSA and the CFTC and the US SEC in terms of leading the development of those principles. So I think that does give us a basis. But the second point would also need excellent cooperation between regulators. But as we've talked about already this morning, I think that is actually already in place. So the building blocks are there in Dodd-Frank and in what we're developing in MiFID and in other jurisdictions. And I think we can leverage on the lessons we've learned from the Foreign Board of Trade regime and from the qualifying MTF regime on what's worked and what has not. I'm confident we can put in place sensible regimes both from a US perspective and a European perspective. I'm looking forward to some more direct questioning from the committee later. Thanks.
David, if I can just add something very, very quickly. I agree with your 2 points. On the first point, to me, it's another highlight of the importance of the other countries, part of the G20, adopting standards in their own legislation that are as comparable as possible to what the U.S. has already had in place. It sounds like exporting our standards, and I don't intend it to sound that way, but I'm only making the point from a practical perspective, because the closer they are, the fewer top-ups, if you will, theoretically would be necessary. So I appreciate making those points.
And just very quickly to come back on that, Chairman, I think I agree with that, and I think that's why it's important that we base our regimes on those international standards. And I know that the CEF regime implements the IOSCO principles I described earlier, as does the European regime, and I think that's a really good basis on which to work from.
Thank you, David. June, did you want to make some remarks?
Well, thank you, Chairman. Well, I'd just like to make some general comments as well as just a few specific comments. Well, I'm just trying to touch upon some kind of Asia-Pacific flavor, if ever possible. On the this electric trading platforms, organized trading platform issue, basically started from Pittsburgh Summit 2009. Then they said that the all standard OTC derivative contracts should be traded where appropriate. Well, to improve transparency, mitigate the system risk, and for protect market protection. Then it followed as David mentioned, that IOSCO issued 2 reports in 2011 and 2012 on the organized trading platforms to try to emphasize the kind of a flexible approach to defining organized trading platform for the purpose of G20 purposes with certain characteristics. I think 7 or 8 characteristics are listed there. To try to maximize the number of the standard product that can be traded on that platform, so that the initiative on the enhanced transparency will be increased. But here, not the kind of a particular form of platforms is prescribed at the IOSCO report. And then a number of the countries since then have tried to introduce or are introducing a kind of a sort of authorization system for the OTPs. Then, here we are talking about the exemption of the USF. Again, the ODRG, the OTC Derivative Regulator Group, are discussing about the various approaches, how to make it deferring to the foreign regimes, such as substitute compliance or equivalence or exemption or permission forever. That work is going on. This is my general comment. And some specific comments. Recently, IOSCO Asia Pacific Regional Committee sent a letter to the CFTC. Recently, issues have emerged with respect to the potential for the liquidity fragmentation along jurisdictional lines. This issue seems to be arise from a so-called footnote issue of the USF regulation, but also it appears that the liquidity have been fragmented between the U.S. person and non-U.S. person, that David pointed out. Of course, I think it's this issue of market confusion is partly related to the issue of possible lack of maybe clarity or predictability of the framework of the regulation, because for at least for various market stakeholders, I think the CFTC already took some action to address this issue. But enhancing the clarity or predictability of the law and the regulation, I think should very much helpful to reduce the regulatory uncertainty and to avoid any consequences and unnecessary burden for the market participants. And in this regard, it's also important to have appropriate transitional measures or a reasonable transition period, especially for the foreign entities, to introduce kind of a new requirement. That's my first comment. Then second comment is that the exemption about the USF issue, Riva talked about the 5G of the comparability and comprehensiveness. Then, as I mentioned in a morning panel, there are 2 issues. How to assess the comparability or comprehensiveness of the foreign regimes. As compared with the PFMI for the CCPs, of course, they're not really such a granular principle, but David said the IOSCO 2 reports have a really good basis for have to lay out some principles or the characteristics. But of course, the granularity of the safe international principles might not be as great as the PFMI. Now, some conditions which might be levied on the exemption are not yet clear. I'm aware that the CFTC issued a no-action letter for the European MTF in February and again in April. But I think it's going forward. I think it's very important that more in generally, the due recognition should be given to the differences in legal and regulatory frameworks or local market practices and characteristics. Because the Europe, US, Japan, other parts of Asia, the markets, and also in terms of the market, the depth or liquidity are different. This may have a significant liquidity impact in local markets. In that regard, I would like to emphasize that the one-size-fits-all approach will not be appropriate in this kind of assessment. Then the last issue, which is a similar issue which I mentioned in the morning. Well, actually, the trading venue issues is closely related to the trading obligation, trading mandate issue. Well, I just take one, and also in the implementation timing of how the trading mandate will be implemented. Well, just one example. Suppose that the yen-denominated IRS is not subject to the U.S. trading mandate, but in Japan, we are basically implementing our the trading mandate at the latest by September next year. In that case, suppose that the U.S. and Japan implementing IRS, yen-denominated IRS for the trading mandate, then well, there's on the cross-border basis, and if there is in this case there should be an OTP which is eligible in both countries for use through, for example, some registration or exemption. When trading obligation in both countries are implemented. Well, otherwise, both U.S. and the Japanese counterparties basically would refrain from trading, or they are not able to do so in fear of breaching the rules of each country. Well, in that regard, I think flexible and also bilateral, perhaps or multilateral coordinated approach among the regulators will be quite important to avoid unnecessary burden and the intended consequences for the market participants. I will stop here.
With that, turn it back to CFTC staff if they want to, maybe pose a question to the group.
All right, thank you all. We put together a number of questions. Actually, I think our first list was probably starting with like 30 questions or something, but rather than scare everybody, we got it down to a smaller number, which I believe was circulated to the members of the GMAC committee. So I'm going to start with, begin with going through this, and certainly, I know this morning Phyllis started with actually kind of taking a step back and asking about the overall, whether this was a good thing to do in terms of the exempt DCO rulemaking. And I don't know if anyone wanted to address it in the context of the exempt CEF rulemaking before we go on to the more specific questions.
I'd like to make quite a general comment. And given the split of the liquidity and the fragmented market feature in place, we should be reminded of the basic, concept of the mutual recognition, and all the regulators have to be mindful of the appropriate deference to each other upon how to interpret the international principles. And based upon that notion, I think that any conditions to be given by the U.S. authorities should be limited to the U.S. personal trades. And plus, thinking about the cost-benefit analysis, we have to be also reminded of the primary intended benefit of the CEF. I understand that is the pre-trade transparency. I think the other types of the benefits, like credit risk concerns, are supposed to be met by the mandatory clearing, and post-trade transparency could be met by the reporting by the dealers. So again, given the fragmentation of the market and the liquidity split, we have to be focusing upon the primary benefit of the CEF, and any condition to be put upon is limited to the trades between the U.S. persons, trades made by the U.S. persons, and those conditions should be those enhancing the pre-trade transparency. Thank you.
Thank you. Was there anyone else that?
Thank you. This morning in the panel, I expressed Citadel's support for the exemptive process in the context of DCOs, and I concurred with David's view that in the process you couldn't separate the customer solution from the proprietary solution. And the basis on which we felt so strongly about that was this notion of fair and open access, which I think is core to the success of swap market reforms. I'm going to come back to that concept and phrase it a little bit differently as open and impartial access to being a cornerstone to the success of swap market reforms, and add to that straight-through processing. Those two concepts we think are absolutely critical. So Citadel supports very much the notion of exemptive authority and relief applied in the context of foreign CEFs, provided that this process ensures the exemption is only granted in those cases where we've made a determination, or the Commission's made a determination, that impartial and open access and straight-through processing exists. As I mentioned this morning in the DCO context, we don't think there can be any opportunity for daylight to exist between the CFTC's very strong and clear regulatory and policy positions on these matters, that is open access and straight-through processing, and the rules that are applicable to the exempt CEFs. Memorandum of Understanding or other similar vehicles are, we think, very important to ensuring continued sort of viability and inclusion of those attributes in the markets where the exempt CEFs exist. If I may just finally mention, we were very encouraged to see that in the recently adopted MiFID II legislation in Europe, they included provisions on STP that very closely parallel the Commission's STP rules. And we think that's very, very important and very encouraging.
If I can just follow up very, very quickly on what Adam said. Again, it highlights for me the importance of some of these standards, and not every standard is of equal weight. Adam identified a couple that are the two of the true hallmarks of our CEF regime, and I think the other critical one, of course, would be the controls around the types of execution methodologies permitted on a CEF for mandated swaps. Those are the three key component parts of our CEF regime. Those are part of the conditions of our MTEF, along with some others. And so I think going forward, we're really going to have to work through this and think carefully about it. And I guess I'd stop there, but ask the panelists the question. David made the good point that there is a set of principles that has been adopted, but I don't know if anyone's in a position among the staff across the room here to identify some of the key principles that were laid out by IOSCO and to what degree they touch upon some of the two of the issues that Adam addressed.
So I can take them. I can take that, Chairman. I have them in front of me, in fact. And actually, if I look back at the authors, I see a certain David Van Wagner as one of the key authors. So, but we won't test him right now.
This is short-term memory.
So the characteristics that IOSCO laid out, just at a high level, included things like registration of the platform with a competent regulatory authority, including requirements related to financial resources and operational capability, access for participants based on objective and fair criteria that are applied in an impartial, non-discriminatory manner, pre- and post-trade transparency arrangements, operational efficiency and resilience, including linkages to post-trade infrastructure, and I'm paraphrasing here not to go into the detail, active market surveillance capabilities, transparent rules, and non-discriminatory or rules that do not permit a platform operator to discriminate. And they also included being multilateral of nature. So I think they capture the key elements that would underpin a sensible regime for this kind of trading, and certainly encapsulate the key attributes of the European regime that we're developing, and my understanding the US regime as well.
John.
I'm happy to just make a couple comments. First of all, I think that if the CFTC and the Commission knew in 2010 what they know now about CEF trading and execution in the OTC markets, we might have had a slightly different outcome on some of the rules, because it's certainly been something that's had to morph over a period of time. I think we've also found out that the futures markets, which the regulators were very used to regulating, is very, very different than the nature of the OTC markets and the cross-border block sizes that are traded in some of the OTC markets. But one of the things, when I talk about the exemptive CEFs, and I think, David, you touched on the IOSCO rules, I think if I look at the CEFs and what Adam is saying, to me, a lot of the futures markets have been based on principles that the CFTC has set. And I think as we go forward, if you're going to have exempt CEFs, you're going to have to do them on principles and not on rules. I think that you've laid out, or IOSCO has laid out, some very important principles that they feel that all OTC execution venues should offer into the marketplace, such as impartial access, open access rule books, all of the ones that you just mentioned. And I think that if you're going to have a global regime that allows for exempt CEFs or exempt trading facilities, they need to be based around certain principles that the regulators agree, as opposed to specific rules.
Kim?
Thank you. I just want to make a couple of comments. First of all, I think, again, we support the concept of mutual recognition that is creating a level playing field between the different jurisdictions. We do think that in some ways for trading venues, it lacks some of the complications of clearing, doesn't have bankruptcy complications. But in another respect, it's perhaps more complicated than getting a mutual recognition regime for clearinghouses, because of the timing differences. The rules for trading in Europe don't go into effect for some time, and it's uncertain whether there will even be trading mandates in many other jurisdictions. So there's not kind of at least uniformity of mandate, or closer uniformity of mandate status. So those are complications. Another complication that we have seen is, again, the fact that the European regime is holding futures and OTC in the same kind of in the same time frame, and so again, the U.S. Or actually, it's not just U.S.-based exchanges; it's any futures exchange that is not located on European soil is in a position where it is already not recognized as a futures contract for trading purposes for parties who are counting their OTC trading as part of their determination of what is called NFC plus status, but it's similar to a major swap participant in the U.S. It's a status that many people would prefer to avoid if they can, and futures that are traded on European located exchanges count as futures and don't count against this status, and futures that are traded on non-EU platforms do count as OTC and count against this status. So in this case, going back to my opening analogy from the morning, we're in a position where the hostages aren't all going to be shot on December 15th. The hostages are being shot now. So we are already feeling the impact of, for certain market participants, the sensitivity to this NFC plus. And again, the CFTC does not put any restrictions on the ability of U.S. persons to freely trade on EU-based trading platforms, foreign futures. So I think we would ask for there to be an acknowledgement of that and perhaps a separation of the decision-making process on futures versus OTC. Then I also wanted to just mention, I was interested in a couple of specific comments that David made. One being that if there are a number of conditions or top-up requirements in a kind of mutual recognition or exemption regime, that is problematic. It's difficult for parties to adjust their business. And it was problematic that the CFTC and the QMTEF reserved the right to expire or withdraw the exemption. And I would like to point out that on the clearing front, those corresponding things are exactly the same things that are being imposed by the EU regime on the recognition of equivalence for clearinghouses. There are top-up conditions being imposed on the PFMI requirements, and there is, and again, I'm at a bit of a disadvantage because we haven't seen anything in writing, but from what we've been able to glean, there are top-up conditions and the 2-year review. So the equivalent status only exists on a 2-year cycle. And so I would need to agree with you that those types of practices are somewhat problematic, but I would suggest that they're problematic whichever side of the pond they start on and emanate to.
Just real quick, what is the rationale for the 2-year time limit on the equivalency determination? Or David or Kim, I'm just curious.
So if I may come on both of those points, and just before I answer that question, Chairman Weedon, just in response to Kim's points, I think my comments with respect to the qualifying MTF regime very much reflected that it's an interim regime where, in a place where you have two regimes where one has implemented new standards, the other is still catching up, and so my comments about topping up requirements were a significant number of them, and the fact that the regime, the status could be in effect could be pulled at any point in time at very short notice with no sort of transitional. But Chairman Weedon, with respect to your comments, I from a personal perspective, and again, I'm not the European Commission, I don't recognise the 2-year window. My understanding was that if given the equivalence that applied full stop, as opposed to being on a 2-year cycle. So that's not a factor I recognise, but I appreciate if it was there, that would be something that we'd need to discuss.
And we're in a position where we haven't seen anything in writing because this is legislation that has to be formulated, but we have had discussions where we have been told that there would be a 2-year review process. So the equivalence would be reevaluated on a 2-year cycle.
Wally?
Thanks. Out of concern for hostages and maybe less sympathy for people who have to work through topping up, but more out of a concern for just trying to understand, make sure we're all clear on what's going on right now. What's the state of play right now? I just have a question that I hope you can help clarify. One of the things that's been going on, at least in terms of what's been reported, is the issue of so-called guaranteeing, where U.S. affiliates are being are no longer being guaranteed. At least the swap obligations of subsidiaries are no longer being guaranteed in some way. I have a couple of questions. What's really, do we know what's really going on there? Because there's different levels of assurance that a parent can give a subsidiary, and is it a question of guaranteed, true guarantee being dropped, some kinds of guarantees being dropped, and how, if any, does that fit into what's the state of play in this discussion right now?
So I certainly appreciate the question, and maybe the members of the GMAC can sort of talk about what they understand on the de-guaranteeing, but we're not in a position here, the staff, to offer an opinion about what we've seen. There's been certain questions that have been posed to us that we're evaluating, us being commission staff, but DMO staff in particular, we're not in a position to sort of address that, certainly in connection with what we're thinking about here on this exempt SEF. But I appreciate the comment, certainly appreciate the interest. I don't know if the chairman, Commissioner O'Malley, want to speak to that.
I'll say something real quickly. When we adopted the guidance, we made a set of policy judgments based on what the statute provided, and it also obviously reflected a number of policy judgments. And if the basic construct of our cross-border policy as it relates to swaps is a risk-based analysis, the focus, which it was, the focus consequently then was on, okay, how in the marketplace today could risk be imported back to the United States? So we looked at a variety of different ways that could happen. We settled on certain legal structures, the foreign branch structure. That was a pretty clear example. A little less clear, but nonetheless, I think pretty compelling, was a trade that was backed by a U.S. parent with a guarantee. Clearly, as a legal matter, put the parent on the hook, so that suggests a pretty good indication of the potential of risk transference. And we stopped there. There are other terms of a contract that perhaps could indicate risk transference back to the United States, and some of those were considered at the time. But again, we had a statute we had to interpret. There were some limits to the statute, and we're also making a judgment based on facts as we understood them at the time. And so whether or not there are new contractual terms that are part of swap agreements, that's what staff has been looking into as of late. New contractual terms, in other words, that would be the functional equivalent of a guarantee. That's what we have to look at, I think, and that's the process that's currently underway.
Superna?
So my point is a little bit just a point of discussion, or maybe somebody on the panel can help clarify. If we end up with an exemption for certain OTFs or foreign CEFs, one concern I would have is that would half my trade flow be under the jurisdiction, under one jurisdiction, while the other half another? Like, say, for example, if we were to trade something via one of the platforms in London, and it happened to be a US CME swap. So the clearing end of it would be under U.S., and then the front end where we're exchanging market risk would be under another jurisdiction. How would we manage that type of risk? Because it's the same trade.
So I think you've probably highlighted a very clear reason why we need an exempt CEF and an exempt DCA regime to work together.
Exactly. I mean, they are somewhat interlinked, and to some extent, you want to have certainty of what's going to happen through a single trade, and it just became the permutation. I was actually trying to write it out. The permutation and combinations become very, very complex.
Can I just ask, I mean, when I understand that there's a complexity there, in terms of that, since there was this, obviously there needs to be some kind of coordination or some kind of recognition on the side of both the clearing and on the trading. Did you have along with that a recommendation as to what we should be taking into account or how we should consider that, or are you just basically raising the issue and saying?
I'm raising the issue right now. I think we need, to see like the final MiFID, rules. There is a lot, of conversations. You have some idea. Not quite sure how we can translate, what we know so far into a principle-based approach. I mean, I think some of the issues were raised, like straight-through processing and things like that. But a couple of others. What type of documentation would you need? Today, if I trade on a USF, essentially I need very little EB documentation. Like, how would that pertain? And a lot of those, documentations for the CEFs are some also intertwined with the CCP requirements. And then I don't know if we consider like void ab initio to be part of straight-through processing, but that will be another concern. What are the rules around RFQ? Like if it's a principle-based approach, some of the fundamental rules which are going to drive how you trade would need to be explained a little bit more. Otherwise, you're going to end up trading on the facility, that essentially matches, what your desired outcome is and where there's liquidity.
Right. I mean, so the point is certainly on trading methodologies, and we associate pre-trade price transparency with those requirements. I do think we will be looking at a principles-based regime. Of course, we've got to balance that with what our Congress told us insofar as being comparable and comprehensive compared to our own. And I do think that an outcomes-based approach is what we've followed in the FBOT regime, the FBOT regime being the regime that's comparable to contract markets for futures. So we're thinking through those issues.
Dave, can I ask a question? If FBOT is principles-based, what is QMTEF?
QMTEF is transitional. We knew that when we as we sat at this table a year or so ago, and we scanned the horizon, and we realized that there was really not a regulatory regime out there at all that was comparable to ours, or really anything that had been built out or mature yet. So the only point of reference that we had was our own for the time being.
Right. So 16, 18 months difference between U.S. rules now, Dodd-Frank, CEF rules, and what's going to be the MTEF, MiFID rules. Do we have time to implement an exempt CEF regime, or should we develop something that works to recognize MTEFs and solve for this at most 24-month solution? I mean, this is now about time frame.
Right. No, I understood. I mean, and we're obviously enough. There's parallel tracks. So the MTEF NAL is the MTEF no action letter is out there now. I would think that in parallel with the exempt CEF rulemaking being issued, or at least the proposed being issued, we might start to look back at the template that is now the MTEF and no action letter, and possibly have to refine it. And would be refined not only for Europe and MTEFs, but possibly other jurisdictions. We would try to be as standardized as possible. But yeah, I think it'll be informed as we go through the exempt CEF process as well. We didn't want to get out in front of the Commission on the exempt CEF process. So the only thing the Commission had told us to date are the CEF rules.
And I think just to touch base just a little on context and focus on what statutory requirements we have, and looking at 2I, the direct effect back to the U.S., but also for made available to trade swaps could only be traded on a DCM, a CEF, or an exempt CEF. But we also had this an obligation to consider effectively, how do we interact with other trading outside of the U.S. in looking at the path forward. And so that's where the QMTEF discussions came about, to sort of recognizing what we have already in statute that we need to be focused on to ensure we have price transparency within the U.S., and recognizing that there are other facilities coming up to speed and aren't close enough yet to where we're at, and how do we bridge.
But shouldn't we take a look at where trading is occurring right now? We've got U.S. dollars trades on CEF. We have non-U.S. persons, non-U.S. dollar trades off CEF. And I don't see what changes, how the market changes as a result of another transitional platform that isn't being utilized like the QMTEF. So in light of the data that we're seeing today, the real life trading experience, what is the right answer? And I throw that open to everybody, frankly, not just our staff. But I mean, why would we, let's look at the data and figure out what it's telling us and about the way people are trading and figure out what the best solution is going forward.
So maybe I can come in on that. So just on that point, Commissioner O'Mara, the fragmentation you've highlighted is real and it's here now. Certainly from our perspective, ideally we would have an exempt CEF and a matching European regime in place now. We can't do that because, to a large extent, because Europe hasn't developed its rules to the same pace as the US. We recognise that. And so the right answer is to have those regimes in place at the point that we can do. And that's not right now. But as you said, it's somewhere between now and 2 years' time. The sooner the better from our perspective. I think the interim regime, whilst not a template for a longer-term regime, is still has the potential to be useful and one we continue to discuss.
Let me just try and see if I can take a stab at Scott's comments and pick up a little bit on what David said. I mean, the QMTF obviously hasn't worked. We haven't got an application. I don't think there's been one application for a QMTF. If there is, I haven't read about it. As Scott said, U.S. trading is basically all being done on a CEF. Non-U.S. trading is all being done off CEF. That's the way it's working. And if a U.S. person wants to trade off of a CEF with a non-U.S. person on an MTF, they are trading in a non-guaranteed subsidiary. So right now you basically have fragmented trading between two platforms. And ICAP, as all of you know, had applied recently and was granted temporary registration by both the FCA and the CFTC for its new CEF called IGDL, which basically was put in place because we were not sure at the time we decided to make this application whether or not the QMTF was going to be something that would come into place and stay for a short period of time or come into place and stay for a long period of time. And we decided that this was probably the most logical way to go forward, was to have an entity that was duly registered by the CFTC and the FCA. And I will tell you that that entity is basically trading US dollar swaps. That is where it is. All of the European swaps are being traded off CEF onto a different, MTF. So we have in place an entity that is duly regulated and which all U.S. and non-U.S. persons are prepared to trade on, but they do trade it on one product at this stage and one product only.
Just one quick point to follow up on John's comments. And back to the overall discussion about conditions and following something as broad as principles gets us to where we need to be in every instance. The question I have, and maybe this is not a rhetorical one, but if folks around the table might be willing to speak to this, if we had no conditions on our MTEF letter, would there be any CEF trading?
Well, when you said no conditions, if your conditions were a U.S. person can trade dollars on a...
So we recognize a platform in London and we say, we don't care about your...
if you're saying that a U.S. person domiciled in the U.S. or a U.S. person domiciled anywhere could trade on an MTF and does not have to trade on a CEF, my guess is most of the trading right now will be done on an MTF.
Yeah. And so back to the point I made at the very outset of the meeting, the statute requires us to consider competitiveness issues as it relates to our policymaking, and so we have to be mindful of what impact our actions will have on our CEF regime. I don't want to sound like I'm overly defensive of the MTEF letter, but I just want the group and the public to have the benefit of our thinking. That's why the conditions are there. In addition to trying to remain faithful to the statutory requirements we have That's why the MTEF letter was constructed as it was. I don't like the fact either that it hasn't had the practical impact that we intended. David and I spoke about that over the lunch hour. We might have some more work to do there, but that's, again, just giving the group the benefit of the thinking and the thinking behind the conditions of the MTEF. But we would like it to be useful. I mean, that's the whole idea.
One thing I would add, though, Mark, that while being cautious of the competitiveness of the CEF regime, we also have to be cautious of the competitiveness of the U.S. banks who have to deal in the CEF regime versus the foreign banks that are dealing in the MTF regime. So competitiveness cuts both ways.
Yeah. Wallace?
Yeah, thanks. All this having been said, from the public's perspective, there are some dynamics going on here that are quite instructive and quite revealing and quite informative. And whatever's being done in terms of de-guaranteeing is avoidance or evasion is an issue, but if it's just avoidance, if it's all by the rules, it would be awfully important to as we think about how all this is going to play out over time, to have a pretty clear understanding as broadly as possible. I'm just urging that to see what's really going on here, because I think there's some important information being generated that we would like to understand. And from the public's perspective, this is being discussed, but being discussed perforce and with less than full understanding of what's going on, and is how much of this is inter dealer, how much of this is customer. So anyway, there's information being generated by actual market activities that I, for one, would love to understand more about, and I think there are many others that are observers would love to understand what's going on now.
Bob?
Yeah, I'd like to go back to John's comments about what would happen if you actually sort of allowed free choice of where to trade, and the observation that non-U.S. participants would not trade on CEFs. I mean, I think that's a pretty profound statement, and it's consistent with our observations as well. And I'd like to draw a historical analogy. I mean, people have often, going back for decades, complained about the regulation of the U.S. equity markets and how strong it was. And I think the answer to that from a policy perspective is yes, but non-U.S. participants flock to trade in those markets, so we must be doing something right. Here we have a regulatory regime that is very tough, and non-U.S. participants are doing everything they can not to trade under that regime. So I think it poses the question of whether the regulatory regime got it right or not. And I think that's something we all ought to be talking about. To some extent, the agency is bound by what Congress put in the statute, but I think there's a lot in the CEF rules that are not strictly dictated by what's in Title VII. And I think stepping back to base principles and figuring out what it is that we want to get out of the CEF trading mandate from a public policy perspective might be a very useful thing to do, both for its own value and also in comparing how we're going to do a comparability analysis. How are you going to look at the regulatory regimes in other countries and which regulatory regimes really fit the public policy goals that you're trying to advance?
Superna, and then John Parsons.
Yeah. I just wanted to comment on the non-U.S. person trading on a CEF. I mean, there are some structural components that, may make for non-U.S. person to trade on a CEF not optimal. I mean, there are only limited number of hours when you have a CEF and a CCP open. So if you're a non-U.S. person and you have the choice of trading on a CEF and then waiting for CCP to open, and then, potentially having like your trade go through like void ab initio versus bilaterally trading it, you may opt to bilaterally trade it, even if it's a cleared swap. So that's somewhat, when we move out of the U.S. time zone, you are seeing, some of the structural components, come into play. And then the other thing is that for non-U.S. person, it is voluntary, just as clearing is voluntary. And clearing, to some extent, you can justify it is helping with counterparty risk. The CEF framework is still, in its initial stages, so it is a little bit, delicate. So you can't confidently say that if you're trading on a CEF, you will definitely be able to execute the risk and have certainty of clearing. So, I don't want to put that in avoidance category. It's just like preliminary stages and a reality.
You are front-running the TAC meeting next week, by the way. So stop it.
Well, I mean, there was...
So, Perry, you mentioned too. You said you mentioned hours of operation as it relates to time zones, and then you said void ab initio.
Yes. So if you trade on a CEF, if the CEF is, open for trading, but like, the CCP is not open for clearing, your trade can sit in a pending status. So you don't know once the clearinghouse were to open if, it is truly going to go through. There is a probability that the trade gets voided out. So I mean, as an asset manager, you want to make sure that you're getting the best price and best execution, for your underlying fund. So taking that type of risk, when there is an option or a choice of trading it bilaterally, whether it's cleared or whether it's bilateral, you opt to do that.
I'm glad I asked because I thought you were suggesting that there wasn't a similar policy of void ab initio under EMIR or European laws. I don't know whether that's the case or not, but it's...
We don't know that yet, sure. So it's more just, for on the trading of, the CEFs piece of it.
John, did you want to? David Bailey.
Thank you. And just on Supana and Chairman Wheaton's comment there, I suspect Europe would end up in the same place as the US on that point. I can't see how it would end up anywhere else, but as Supana says, we need to see the final MiFID rulemaking. So I just wanted to come back to some points that John made and Robert made about disparities between the US and the European regimes, and what would happen if there were no conditions applied, for example, in the QMTF regime. And that whatever that would imply in terms of trading, we just need to remember that is an interim situation where you've got a finalized set of requirements versus in Europe a still to be finalized set of requirements. I think when we've got the European regime finalized, the regimes from a regulatory standpoint will be extremely comparable, and therefore regulation will not be a driver of where business is done. There will be other factors that will influence where business is done, but it will not be regulation. And therefore, at that stage, we won't need things like top-up requirements.
David, I don't disagree with your comment at all, other than I would suggest that many cases around the world, it's the regulator that this the regulator that you're most comfortable in dealing with. And having somebody in a foreign country or in Asia having regulatory oversight by the CFTC is somewhat difficult for them to actually understand and comprehend versus their local regulator. And I think that would probably still apply in Europe, although I do agree with you that the rules will look very similar.
Commissioner O'Malley, did you?
I guess I'd like to get the GMAC's opinion, the member panelists, their opinion on the path forward for the next 18 to 24 months. Is we've kind of defined where we have our differences. Should we try to breathe life into the QMTF? Should we pass a exempt CEF? Should we get on some sort of a comparability regime now to recognize MTEFs? And I would also ask that you opine on what the recognition regime for Europe might be. Should they recognize CEFs? Is there a comparable, Kim raised the issue of DCMs, et cetera, and CEFs. Where do we stand on that? What do we do for the next 18 months? Do we throw up another idea that we have little to no understanding will work or not? Or what's the best and most efficient path forward to really bring trading on screen?
Let me just say real quick in response to Scott's question, I don't think the solution would be an exempt CEF rulemaking, although we'll have to continue working on that. And I say that because there wouldn't be anything to compare it to until MiFID is implemented. So we'd have to have something, we'd have to have an interim solution in place up until the time MiFID is fully implemented. Disagree with that, Vince or Scott? Or David, sorry.
I think that's right. David Bailey can probably speak to the circumstances that, or the authorities that FCA has that are unique. But when we had discussions prior to drafting the MTEF letter with European regulators, it was quite clear that they really did not have anything that they were going to be able to offer us that would come anywhere close to what the conditions that we put into the letter. We were more encouraged, frankly, because there are mechanisms that the FCA has to close that gap and to have less topping up, I guess, as David would describe it. But I mean, fundamentally, when there is such a gulf, it is very hard to do anything other than to say for this commission to say not impose any sort of CEF requirements at all, because it's really a very distinct discrepancy as far as swap dedicated platform regulations go. I mean, David maybe can talk about the mechanisms that they can at least bridge that gap to a large extent, but.
And as I hear it, I think the one focus that we have is this very strong need to be proactive, as Commissioner O'Malley and Chairman have touched on. Sort of how do we get to the future state, recognizing that where CFTC facilities are and how the mandatory trading is only 3 months old, and we're working still on implementation of trading on the CEF facilities, while at the same time sort of recognizing the significant question about fragmentation and attraction. Frankly, we want people to trade on CEF. We want it to be competitive. We want these markets to do what they're intended to do, which is handle this price discovery process and risk these risk-related issues. And so we can't wait. We can't wait 18 months. And so we have been working in these communications, and something will come out of it. Where the expectation might not be, if QMTEF isn't a viable option, then an entity will go that way. And if it's not a viable option, this CEF alternative might come up. So I guess this is my way of saying that we continue to work on this issue, and frankly, that's one of the reasons why we're here, is to get the feedback about what are the areas that we should be focused on, and the items that we talked about earlier, on the pre-trade transparency in particular, sort of where do we crystallize around, so we have a sense that we're going in the right direction, and I think that's very helpful.
Chris, did you give up?
No, I was just going to make the point that this question of who is using and who's prepared to use CEFs. I mean, it typically for many of the overseas institutions and non-US institutions that are already swap dealers, they're perfectly happy to use CEFs, and in fact are contributing prices into CEFs at the moment. To the extent that we're essentially talking about RFQ markets, many overseas dealers are quite frankly agnostic as to whether they're streaming those prices into CEFs, MTFs, or other types of execution venue, and that's what's happening now. But the reluctance does derive in part from parts of the customer and client base who are not so keen about being brought into the scope of the purview of US regulatory oversight in circumstances where, were it not for the execution of business through a given platform, they otherwise would not have been caught. So I think it's worth bearing in mind that this is the discussion that people are having around the incentives or disincentives and the motivation factors behind who's using the platforms is not really a question of sort of foreign swap dealers and entities of that sort. They're perfectly happy to use these platforms. It's the underlying end users who are not registered swap dealers or MSPs.
Wally?
in going forward, one thing I want to make very clear, a different point than was put forward. It was put forward that the equity markets were used despite regulation, and we got it right somehow. The regulation of derivatives is for a completely different set of purposes. So if people aren't using them, that could be a very good indication that we got it right. In whichever way forward we decide to go, let's assume that the right analysis is we actually got it right. The purpose should be to get to get people to use it through incentives, positive and negative, whichever incentives, but to do it in a way that's perhaps better.
Kim Taylor?
I had been thinking about Bob's point about the equity market too, and here's what I think is the difference. There's not really a good alternative way to get exposure to U.S. equities other than to trade in that regime. And there is a perfectly good way to get exposure to derivatives without touching the CFTC's regime because you happen to go first. And I think it's perhaps clear that some elements of the regime are less attractive than not having any kind of restrictions. If you can trade bilaterally in Europe and you're not subject to CFTC regulation, or you're not subject to pre-trade transparency, or you're not subject to anything of a trading nature because those rules aren't ready yet, then it's a pretty easy choice to make to be voluntarily subject to extra regulation or not. And I'm not sure you'll be able to make an evaluation, unfortunately, about which regime is the better one that people actually prefer until there's more than one regime in place.
Emily, did you want to say something?
I was just gonna, I guess, kind of add perhaps on both these points, but Chris, your point about the end user, is ultimate. I mean, I think we can't lose sight of the fact that the ultimately U.S. persons, the end user, is blocked out of major pools of liquidity, of basically non-dollar liquidity, and that is not good for the U.S. and for end users. And I think it might very well be that there is an interim solution where some form of principles-based solution that MTFs, et cetera, for a period of time are recognized. It at least goes towards the promotion of screen-based trading and more transparency until the regimes are fully completed. But at the moment, you're stuck in a situation where it's truly, I think, detrimental to both U.S. broker dealers as well as the end user.
Raj.
Yeah, I just want to make two comments. One, since Bob's not in the room, it's a little easier to make this comment. But I mean, equity markets didn't start out perfectly in the 90s. I mean, we had a duopoly, we had scandals of collusion. It wasn't always great. And now, arguably, because the SEC stepped in, we have a far too complicated market structure today. So I think that using that as a paragon of virtue is not necessarily appropriate. The second thing I would say is in and around. I feel the conversation is really limiting us to two choices around CEFs and foreign CEFs. I mean, there is a third way, which is exchange traded instruments, deliverable swap futures, and in particular, you address really four aspects of that. Four aspects of the problems. You get price transparency. It's vertically integrated with the central counterparty. Some of the most liquid markets in the world are traded there. And increasingly, as a large participant in those markets, we're seeing your customers, and this is really directed to the banks, start to participate directly in those markets, especially with respect to interest rates. So I wonder if we're really creating a false choice here between two different options when there is a third way. But I suspect I'm going to get a lot of resistance to that because that would, in effect, you would disintermediate banks.
just for the record, actually, I think all of these things will exist over time. I don't think any of them are mutually exclusive. You will absolutely, and we've already seen a growth in swap futures. Certainly, I think you'll get to more exchange trading of swap-like contracts or products. But I think you'll continue to also still have a bilateral market will probably still exist to some degree. I think all of these things will coexist, but I think it's just a matter of timing. And I still come back to the point that at this point in time, you are putting, and we can't for that much longer, put a U.S. person at a disadvantage in terms of trying to be able to kind of hedge the risk, et cetera. And we do need to think of a solution in the interim. I think you're right. This whole marketplace will evolve, and we will see all of those things happen.
Raj, do you see any points of resistance, though, to market participants, particularly on the buy side, embracing those markets? Like, what if anything, does the CFTC need to be thinking about there? If they have a need, a hedging purpose, an investment purpose?
Well, I don't want to steal Kim's thunder here, but the CME is actively targeting the buy side to come and trade futures, block futures, and deliverable swap futures. They're speaking to the sort of household names on the buy side around this. Now, 12 to 18 months ago, I would have said that there was more reluctance, but as a direct market participant in those products, we're seeing an extraordinary amount of participation, as evidenced by order sizes coming through those markets to suggest that we are seeing more adoption of those products. And you solve a lot of the problems I've been listening to here by adopting those products around price transparency, a point that Adam brought up, the regulatory burden that John and Robert brought up, the CCP problem that Superna brought up. They're all addressed with skipping that step and going directly to a central limit order book.
June, you've been very patient. Did you want to say anything?
Well, thank you. Actually, Commissioner Omaria raised the issue of how to fill the interim period, so-called 16-month gap until the MiFID will be implemented in sometime later. Well, actually, similar issue we may have in Japan as well, because as I said, our statute require the JFSA to implement the trading mandate by September 2015, which might be a bit earlier than the MiFID case. Well, in that case, we are putting some requirement of the Japanese, the organized platform, and also the trading obligation by that time. In that case, well, I don't know when this draft exemption CFTC rules will come out, but I think we may need to have a similar arrangement with your European colleagues, like interim arrangement, so that if the requirement comes into place. So I think anyhow bilateral, at least the close coordination between the CFTC and JFSA will be really needed, so as not to have any market disruptions.
John, did you want to weigh in?
I just have a question. It's mostly actually for Emily, because you use this language as if U.S. persons don't have access to certain liquidity pools in certain currencies, as if they're blocked. But Raj was talking about one avenue. John had described another avenue. It's not currently used, but I don't see why it's not feasible, and I'm happy to hear about why is it not feasible to provide that same avenue to customers for other currencies.
No, I guess just to clarify, so I think certainly swap futures are a way that U.S. participants can hedge risk, but they are only relatively new products. Not there are relatively few of them. They're not widespread. At some point there will be many more, and that's great, and could potentially be used in much more scale. But at the moment, it's just going to take time for that to even be thought of as a full alternative to the rest.
But the Eurodollar market is the most liquid market in the world.
And the other thing I was going to just say is just from if an MTF registered as a CEF, a U.S. person could access it, but as we know, no one has done that yet. No MTF has done that. So to the extent there are liquidity pools that are centered in certain jurisdictions where there is not a CEF that's not where the SEF is not registered, then it is, for all intents and purposes, a U.S. person cannot access that liquidity pool because they have to trade on a SEF.
Well, John mentioned having it. It's just that only dollars were being used, but it's feasible in other currencies, right?
Yes, one of the reasons that we have a duly registered CEF and MTF is so that European clients can be comfortable dealing under both regulatory regimes. Quite honestly, we thought that that was what was going to give some regulatory certainty to clients on a cross-border basis. I would like to pick up one just for a second on what Raj said. I think that, Emily's right. These things evolve and they take a period of time. And you're right, the Eurodollar market is an extremely liquid market. So is the foreign exchange market, so is the U.S. Treasury market, and so is the interest rate swap market. And they are all traded off exchange. And it's going to be a long time before we can get a $500 trillion market to just trade on an exchange. I'm sure Kim would be very excited about that. But it's going to take, obviously take a little while before we get anywhere close to that. And so consequently, you are going to have to manage change in an evolution, not in a revolution, over the course of the next number of years, quite frankly.
If I could raise the issue of, there's been definitely a lot of issues raised regarding what's necessary, that there's an interim period. Certainly, aside from the fact that they're obviously over time, the staff will look at what might be done in the interim period. We are still trying to move forward with rulemaking, and I know that there was questions sent out, and just to point out that those questions, besides following regulatory approaches, which I think we've covered to some degree, we had questions about reporting, financial resources, financial integrity of transactions, effects on swap market liquidity, monitoring of trading and trade processing, system safeguard and compliance. Does anyone have anything more specific on one of those issues that they want to pass on to us so that staff actually can, take into account your views on those issues? It would be really helpful to know.
So I think, what you're hearing is we're evaluating what our obligations are, what was the current registration regime that we face for CEF, and if there is going to be an exempt category, and we know we don't have standards like they do for the exempt DCO, but we do know that, the correlation between the exempt DCO and an exemption category for a foreign swap execution facility would be important. So we might need to, say, catch up in some respects to what the exempt DCO rulemaking team is already doing. Phyllis touched on the fact that, they have words on paper are pretty concrete. We're not there yet, and in part because we're trying to get crystallized around some of these concepts. And so talking about what Riva has just touched on, reporting obligations. I know Commissioner Malia had a comment at the beginning of the day today, but if we can center on some of those items, if in the remaining time that we have here, if there's any feedback that you think that we should take away on reporting obligations for this exempt category, system safeguards, sort of where do we draw the line between principles and prescriptive approach and making a determination of what is a comparable and comprehensive framework, and so we can think about applying it. So we sort of put that out there in one massive Q&A, and Riva can go through some of the topics again slowly, and we can see whether, as in the time we have, whether there's some comments that make sense to throw out there and have a discussion on. So,
Ramo, did you have any?
In the list of topics that we have, I think one of the things that it drives towards is to make all the CEFs look more and more like exchanges. And I think that the difference between a commoditized, high volume, lower value activity and a less voluminous but more high value transactions is significant. And I think that pushing everything into a commoditized, set of rules as an exchange, I think is not, always the best route. I think the key here is to ensure a large number of such entities or CEFs or whatever platforms, as you would have a large number of brokers or a large number of banks, as against kind of have very highly concentrated one or two execution facilities which just commoditize these instruments over time. And I think that commoditization versus specialization option is really a choice that the end customer makes and should not be driven beyond a point by regulation. I think that's something that if you go on each of those topics by principle, should a CEF fail? No, the answer is no, it should never break down, right? Should it report within a second the price? Yes. So are you going to, so you'll end up very much defining what is a commoditized exchange platform definition today. So I think that's something to worry about when you go through each of these topics.
If I can ask just a further question on that, there is obviously Commission have in the past had regulations, guidance, whatever, that go from anywhere from very specific requirements to principles. And I understand your point, but what we're trying to understand is, for instance, just reporting. When it comes to reporting, is there something on this foreign-based swap execution facility? Should it be appropriate that a foreign home country regulator have a reporting requirement that they place on that facility? Should there be any requirements that we should have, or should it be there should be no reporting requirements? Does that foreign facility need to, is it appropriate that that foreign home country regulator require that foreign swap facility to provide reports of post-trade transparency to the marketplace, to provide pre-trade transparency? As was mentioned, that's something that CEFs can offer. Is there something in between the two extremes that is appropriate, that we should be, considering we have this requirement that we make this finding, is there something that's between these two extremes that is appropriate to place in terms of, just for instance, in reporting, that that we should, some standard that we should find is necessary for us to find that foreign regulator has the appropriate regulatory oversight and supervision?
Yeah, I guess it's fair, and the principles there are pre-trade price transparency and post-trade exposure reporting. And I think that's what you got to push for. Every platform should have somewhere or the other the post-trade exposure requirements fulfilled, and similarly the pre-trade price transparency fulfilled. But whether it needs to be specifically here or not, I think needs to evolve.
Riva, can I also just say that just in regards to that one question or your point, it's hard to find, you can't just leave it as let the Wild West decide. There needs to be something between here and there, between the principle and some sort of specific rules. But also I think you should take into consideration, what are the rules that can be implemented by the provider that is actually going to make his service more competitive to somebody else's service? Because to a certain extent, service providers often lead with innovation. And if they can provide services that they believe are better, they're more compliant, they're more robust, they report better, those are the services that you're going to find institutions are probably going to turn to. They're going to drive to that highest common denominator. So I just think that needs to be considered as you make your determinations of what needs to be very specific versus what needs to be more of a principle.
Superna?
Yeah, to your question on reporting, here in the States we have the CEFs do the reporting, and whether we're talking about CEF trading or clearing, reporting is like one-sided. The buy side actually is not really reporting unless buy side to buy side trades, and that hasn't begun yet. If something like that could be maintained, that would be a preferred route for the end user, because in certain instances overseas there's dual-sided reporting, and that yet, first of all, it has to yet to be commoditized and made to work efficiently, but also just for the broader end user, it is a completely new requirement, and it is to some extent very cumbersome. So we'd like to see our current reporting structure somehow persist in your in the exemptive order. I don't know how you would do that because it may be less than what's done internationally.
There's nothing magical about 3:30, so unless, I didn't mean to interrupt, Reva, if you had more questions. No? Okay.
We have a number of questions. If people are willing to sit here and answer our questions, I can keep on going with questions.
But I do think, I mean, there's some of the feedback that we've gotten this afternoon, we're sort of able to pull this in and come back out to participants and have more focused discussions around some of these elements, certainly. But we wanted to get at the high level sort of where the reaction is, and we've heard that, I think, throughout the course of the last 2 hours, where structurally the market should go and how, in an exempt CEF, how we might facilitate that relationship. So.
I would just want to make one kind of ending comment from our perspective. I think you would want to be careful in examining a temporary exempt CEF or a temporary CEF relief, or MTEF relief regime, that you consider the implications of the exemptions that you're allowing on the ability for the truly registered CEFs to be viable. Because if they have to operate in a very unlevel playing field, that is going to be a recipe for difficulty in the CEF regime building any traction, I would think.
I just want to add one more thing. Will the exempt CEF have the ability to put in the request for made available to trade? I think that would be a little bit of a, that would be a concern.
Submit a product for a MAT.
Yeah.
Oh, I don't think so. I think it's limited only to the, I think MAT's only limited to a registered CEF.
Yeah.
Right. I wouldn't anticipate, but I would think market forces are such that you're going to find typically if something is mature enough to be made available for trading, you're going to have a CEF who's probably going to list that product and do just that. So we're not envisioning that an exempt CEF could trigger it, but I mean, you can speak from your perspective of watching an exempt CEF with a good product. What would you do?
Well, I mean, if we are, looking at this, for the next 12 months in order to be able to give the U.S. person access to some of the non-dollar traded swaps that may not be offered by, the registered CEFs, then how do we solve for that? I'm not suggesting that we allow them to. That would not be a good idea. But what I'm hearing is that our interim solution, are we giving access to the U.S. person, or maybe alongside that we also want to encourage the non-U.S. person to start trading electronically.
Yes, on a duly registered CEF.
Or in yours.
Just to raise another question, since I think there was a pause there, just to pick another subject, which is monitoring of trading and trade processing. In terms of, in the past, you've had the U.S. system, which was, in the futures markets, you have there's large trade reporting that comes to us. The commission is very involved in an oversight. You plus separately have each of the exchanges who do their own monitoring of trading. And there is, so there's a kind of a dual system going on. There's a lot of oversight and a lot of attention to the markets that are either on real time or on very soon thereafter, T+1, that goes to what is happening in the marketplace. And certainly, as we look at our system, we see changes around the world. There is beginning to be some changes that are we're beginning to see, for instance, in Europe, there's now going to be requirements for position limits. There's going to be other requirements, but we still have to make a decision again, back to our standard that we have to make this finding. And one thing we're trying to sort out is here we have this requirement in a sense on ourselves as well as on the marketplace. Is that appropriate, or is there, if we're looking to foreign entities, is there certain requirements that you'd want to see just on the marketplace that they carry out? Is it appropriate that we would expect also that a regulator itself carry out some kind of oversight when it comes to monitoring of markets? And that it's monitoring and surveillance of markets.
So left with us. No worries.
Well, maybe this is a good place to wrap it up. I just want to know if Chairman Wiegand or Commissioner Amalia, do you guys have any closing remarks you'd like to make?
Well, first of all, let me thank our witnesses and our staff that have contributed to this debate, and certainly our panelists who have traveled and spent a lot of time here. The first panel was very interesting and has really made me think about a lot of things that that the chairman and I have been chatting up here about and thinking about and turning around and thinking, how do we do this differently? As is the debate around the second panel too. And I think we really need to look at the data, figure out how the market is moving, what changes are in place, and how we set ourselves up, working with our colleagues internationally to make sure that we close the differences as quickly as possible. And I've had an opportunity to talk to David and appreciate his candor and thoughtfulness on these issues, and certainly his contribution to come here, and June as well. Thank you for your contribution to come this distance. So representing both your governments and others, frankly. So thank you everyone for contributing.
Thanks, Commissioner Amalia. I have to say, I have to make, I think, some similar comments. I think that today's meeting has perhaps raised more issues than it has closed out, and I think that's true probably of potentially both panels. And so, in that respect, it's been very, very valuable. In other respects, perhaps a little disappointing, but I think all of it is in the public's interests and in the interests of the markets that those around this table care very much about and are heavily involved in. So very, very useful, productive session today, and I thank everyone for coming, especially our friends from Asia and our panelists, June and David. Really appreciate your valuable input today. It was very helpful to the conversation. Thank you very much.
Great. I want to echo those comments. Thanks for everybody for being here. I also want to thank the CFTC staff, Margie Yates and her team, for all the work they did to set this up logistically. So with that, as the GMAC DFO and temporary chair of the committee, I adjourn this meeting. Thanks.